Welcome to the deep dive. So, when you picture legal life in classical Athens, what comes to mind? I mean, probably the big names, the famous orators, right?
Yeah, the clash of arguments, those huge public jury trials, the dike.
Exactly. Where hundreds, sometimes even thousands of citizens would decide a case, all in a single day. It sounds incredibly dramatic, high-stakes public spectacles, really central to Athenian democracy.
In that picture, it's definitely right for, the big political fights and the really high-profile public stuff. But here's the question we need to dig into. Did every single conflict, especially the messy personal ones,
Like neighbor disputes or business deals gone wrong.
or even relationship issues, yeah, did all of that really have to blow up into this massive, expensive, super time-consuming public performance?
That's really our mission today. We're asking if Athenian legal culture, which we always hear was so litigious, so argument-heavy, also had ways to, well, compromise, to find justice outside those big, famous courtrooms.
hmm And we've looked at sources that show both sides of this, the high drama of the courts, but also the quiet practicality of people finding ways to settle things.
Appreciated settlements.
Exactly. The key thing here, maybe surprisingly, is that Athenians were actually pretty practical folks. For private conflicts, they had a really solid mechanism, arbitration.
Arbitration. Okay.
Yeah, it was generally less formal, often quicker, and crucially, it aimed for a resolution that felt more, well, equitable, fair to both sides. It shows a legal system that, even with all its love for fiery speeches and courtroom battles, really understood the value of compromise.
So we're going to look at what this private arbitration actually looked like, how it worked, especially compared to the potential chaos of the big public trials. Okay, so let's set the scene first. This Athenian society, our sources describe it as highly agonistic. What does that really mean in practice?
Agonistic is key. It means competition, struggle, rivalry, agone was just woven into the fabric of life. Conflict wasn't seen as like a system failure or something weirdly pathological.
Not like how we might see it today, as something to be avoided at all costs.
Right. It was just a central, expected part of social and political life. Pursuing honor, status, winning arguments, that was the game.
And litigation, going to court, fits into that.
Perfectly. Often going to court wasn't about finding a final resolution and shaking hands. It was actually a tool to keep the conflict going, to escalate it.
Really? To pursue it?
Yeah. Remember, Athens didn't have a public prosecutor like we do, no district attorney. Everything ran on private initiative.
So you had to bring the case yourself?
Exactly. You, the individual litigant, and the courts. They became the prime arena for this. A place for revenge, for damaging someone's reputation, for carrying on these long-term feuds, these ekthra.
So launching a lawsuit was almost like declaring war, and the trial was the battleground. But you mentioned the trial structure itself. It sounded built for speed and drama, maybe not deep investigation.
That's a really crucial point. The trial was like the ultimate stage play, and it ran on a timer. They used a water clock, the clepsydra.
Ah, the water clock.
Yeah, which meant speeches had to be tight, maybe even a bit frantic. The focus wasn't necessarily on laying out all the facts calmly, but on making the biggest rhetorical splash in the minutes you had.
And it was mainly just speeches.
Often, yeah. The core was just two opposing speeches. That gave the litigants huge leeway to frame the story, spin the facts, play on emotions, whatever suited their goal of winning, getting revenge, or securing money.
Okay, so high pressure, limited time. Who's judging all this? You mentioned the jury system, the dikasterion. It was famously huge, right?
Oh, it was an absolute beast of an institution. Every year, they'd select 6,000 citizens' men, over 30 by lot, just randomly picked to be potential jurors for the year.
6,000.
Yeah, they take a specific oath pledging to uphold the laws. Then, 5,000 of them were arranged into 10 panels called decores, 500 citizens each.
500 jurors for one case. That's enormous, even compared to our juries.
It is, and the other 1,000 were reserves, just in case.
With that many people and the time pressure, how did they stop powerful people from just, leaning on the jurors or bribing them?
Ah, that's where the Athenian love of the lottery came in again, sheer logistics and randomization. The archons, the officials, would use the lottery on the morning of the trial to decide which decury panel would sit in which court and hear which case.
On the morning?
Yep. Right up until the last minute, basically. It made it almost impossible for a litigant to know who their specific 500 judges would be. So targeted bribery or intimidation, really, really hard to pull off. It was this institutional commitment to randomness to fight corruption. Most paranoia-proof, you could say.
Okay, that makes sense. Randomness is a shield. But when these 500 citizens are sitting there listening to these timed speeches, what are they actually basing their decision on? They can't be doing a deep dive into the facts, can they?
This is where Athenian justice really diverges from our modern ideas. It leaned heavily on morality. Their laws often set out quite general categories of wrongdoing, not super specific definitions.
So, less technical detail.
Much less. And because the jury was huge and time was short, the decision often boiled down to what you might call a general moral assessment of the person on trial.
Moral assessment.
Yeah, the jury wasn't just asking, did this guy technically violate Law X, Section Y? They were asking, more fundamentally, is this person, based on his reputation, his past actions, his character, is he the kind of person the law warns us about? It was a judgment on character, on their standing as a citizen, as much as anything else.
So you're arguing about who you are, not just what you allegedly did.
Okay.
But even for that, you need evidence, witnesses. Yet you mentioned earlier, and our sources back this up, there was this huge problem with witnesses. They weren't trusted.
This is one of the most, well, counterintuitive bits for us. Because Athenian society was so agonistic, so focused on loyalty, standing by your friends, your family, your allies, witnesses were often expected to lie.
Expected to lie, for their side.
Generally, yes. Or at least heavily shade the truth. Solidarity often trumped objective testimony.
Wow, that changes everything about how a trial works.
It absolutely does. If you, as a litigant, know the other side's witnesses are probably lying out of loyalty, and maybe yours are too, you can't just rely on he said, she said.
So witness testimony alone wasn't enough.
Not really. And there wasn't cross-examination as we know it, no professional judges guiding things. So litigants had to pour their energy into rhetoric, attacking the opponent's character, highlighting their own contributions to the city, making themselves look like the better, more trustworthy citizen.
So they needed other stuff, documents.
Exactly. They had to bring in supporting evidence, written depositions, contracts, sometimes testimony from slaves obtained under torture. Unfortunately, anything to bolster the shaky witness statements, because just relying on someone's word, highly suspect. The court felt less like a fact-finding mission and more like a reputation contest.
Okay, so if the public courtroom is this kind of chaotic, high-stakes moral cage fight, often aimed at continuing feuds, not ending them, what if you just wanted a problem solved?
Quietly.
Yeah.
Fairly. That's precisely where the appeal of compromise comes in. That pragmatic desire for just getting things sorted.
And that leads us to arbitration.
Exactly. Long before a dispute could spiral into that nasty public reputation-shredding mess in the dikesterion, friends or family might step in.
Trying to mediate.
Yeah, attempting to reconcile the ekthroi, the enemies. Often mutual friends were the best bet. They knew both sides, they had social standing, maybe some leverage, and they could push for a solution outside the formal legal system. They understood that a negotiated deal could actually mend fences, restore social harmony in a way that a public verdict, which always created a clear winner and a clear, often humiliated loser, just couldn't.
And we actually have a fantastic, incredibly detailed example of this private arbitration. It's just one case, but it tells us so much. The dispute over iniuria.
Ah, the iniuria case. Yes, it's a gem. It really highlights the informality, the search for a fair outcome, and the sheer complexity that the public courts probably couldn't have handled well.
Let's unpack it. What was the actual dispute about?
It's a bit tangled, as these things often are. It involved two men, Phrynion and Stephanus, and the woman, Neaira. Phrynion basically started proceedings, claiming Stephanus was interfering with his rights over Neaira. Phrynion had tried to seize her, and also that Stephanus was holding onto property Neaira had taken from Phrynion when she left him.
So it's about control over Neaira and money, property. It's messy, personal and financial.
Deeply messy. Probably impossible to get a clean, simple judgment under a strict law that satisfied everyone.
So instead of going to the public court, they chose arbitration, a voluntary, custom-made justice system. Who did they pick to decide?
The way they chose the arbitrators was really smart. It aimed for balance and trust. Phrynion picked one guy, Satyrus of Alapes. Stephanus picked another, Surius of Lamptrae.
So one representative for each side.
Kind of. They probably acted a bit like advocates, ensuring their party's view was heard clearly. But then, and this is crucial, they jointly agreed on a third person, an impartial arbitrator, Diagiton of Acharnae.
The neutral party.
Yes. This wasn't the stakes stepping in, it was them voluntarily setting up a system they both trusted to be fair, based purely on reputation and mutual agreement.
And where did this happen? The setting seems significant too.
It really does. The sources tell us they met in a sanctuary.
A holy place, like a temple precinct.
Probably. Choosing a sanctuary takes the whole process out of the everyday political hustle of the agora or the courts. It puts it in a space that's, religiously serious, maybe calmer, less about confrontation. It suggests they were aiming for a resolution reached with mutual respect, maybe even feeling the weight of a sacred oath or agreement.
Okay, let's get to the verdict itself. Because it wasn't just Phrynion wins or Stephanus wins, was it? It sounds like a really complex balancing act.
It's a masterpiece of equitable compromise, honestly. And the fact that both sides accepted it shows it must have hit the right notes. There were 5 main parts.
5 parts. So.
First, iniuria's status. Big one. She was declared free and her own mistress.
So not a slave, not property?
Legally, yes. Second, the property issue. She had to return to Phrynion the stuff she'd taken when she left him, except for things bought specifically for her.
Ah, like what?
Clothing, jewelry, and significantly her personal slave women.
That's fascinating. So they acknowledge Phrynian's financial claim on the bulk items she took, but carve out an exception for her personal effects, things directly related to her person and status. It respects her dignity somehow.
Exactly. It's applying the spirit, not just the rigid letter, of property rules. A public court might have just ordered everything returned, a clean sweep, but the arbitrators here recognized she had some kind of right, or at least a strong claim, to items acquired for her personal use. It's nuanced.
Okay, so status clarified, property divided carefully. What was the third part? This one sounds pretty wild from a modern perspective. It's about her future, right?
This is the most debated part, and yeah, it sounds strange to us. The verdict said she had to share her time equally between Phrynion and Stephanus.
Share her time.
Right.
Like custody.
Sort of. Or, the verdict allowed, they could reach some other arrangement if they all agreed. And fourth, whoever she was staying with at the time had to cover her expenses.
Okay, hold on. How can she be free and her own mistress, as point 1 stated, but then be told she has to divide her time between these 2 men? That seems contradictory.
It absolutely seems contradictory through our modern lens of individual autonomy, but you have to think about the context.
Is socioeconomic reality.
Precisely. The arbitrators were likely dealing with a situation where both men had probably invested a lot, financially and socially, in iniuria and her life. Declaring her free settled the legal question she wasn't Phrynian's property to be seized, but the time-sharing arrangement. That seems to address the ongoing claims, financial, social, maybe emotional, that both men felt they had.
So it wasn't treating her as property, but it was acknowledging the complex web of obligations and investments surrounding her, a way to stop the feud from just reigniting over who got her.
That seems the most plausible reading. It was a pragmatic way to balance her legal freedom with the powerful men's demands and investments, preventing further conflict. It was a deliberate move away from the simple win-lose verdict of the public court towards a messy but workable compromise.
And the final point of the verdict really hammers that home, doesn't it?
It's the kicker, point 5. The disputants, Phrynion and Stephanus, were thereafter to be on good terms with one another and to bear no grudges.
Wow. You have to be friends now. No hard feelings.
That's the explicit goal. It's not just about the legal ruling, it's about fixing the relationship. Restoring filiu-friendly relations and killing the ecthra, the feud, that's fundamentally different from just getting a judgment. Arbitration aimed for social peace.
This tension you describe between private feuds and the state trying to impose order, which arbitration helped navigate in the iniuria case, that seems like a really old struggle in Athenian law, especially around really serious stuff, like homicide.
Oh, absolutely foundational. You can see it clearly with Draco's homicide law. This goes way back, 621 or 620 BC. It's probably the best example of the early Athenian state stepping in forcefully to stop a major social problem.
Which was?
The tradition of blood feuds, retaliatory killings. Before Draco, if someone killed your relative, the duty fell on the family, the kin group, to get revenge, often violently, which of course could lead to endless cycles of killing.
Vendettas.
Exactly. Draco's law basically said no more of that. It asserted the state's authority, its jurisdiction over homicide cases. It successfully stamped out the custom of just going out and killing the killer or their family in revenge.
So the state takes over the punishment. But did it completely ignore the old family role? How did it balance state control with those deep-rooted traditions of family duty and honor?
That's where the law was quite clever, really. It was a compromise. Yes, the state controlled the trial process, no more self-help revenge. But the victim's family, the kin group, still had an absolutely vital role.
Which what?
They, and only they, had the legal right, the standing, to actually prosecute the accused killer in court. This formal lawsuit was called the dike.
So the family had to bring the case.
Yes. And maybe even more importantly, only the kin group had the power to formally pardon a convicted killer.
The family could pardon them, even after conviction.
Yes. This meant that the essential elements of the older system, the family's central role in demanding justice and granting forgiveness, the ritual cleansing, the social closure were preserved, but now channeled through and supervised by the state court system.
So the state runs the trial, but the family are the gatekeepers for starting it and for granting mercy at the end. It keeps the feud contained socially.
Exactly. But, like any system, this kin-based prosecution had its own potential problems. What if the family didn't want to prosecute? Maybe they were scared, or bought off, or just didn't care enough.
Or maybe the person who felt most strongly about prosecuting wasn't technically close kin?
Right. What happens then? This is where Athenian law shows its flexibility, or maybe its complexity. It offered other ways to handle things, like a procedure called accusation. Seizure.
Accusation. Okay, so that's technical. How did that work differently from the normal homicide suit, the dike?
Accusation literally means leading away, or seizure. It seems to have been a kind of summary procedure, originally maybe for catching people red-handed thieves, bandits.
Like a citizen's arrest?
A bit like that, yeah. You could seize the suspect and haul them directly before the magistrates called the 11, who dealt with prisons and executions. The key difference for homicide was this. The dike required the prosecutor to be a relative, but accusation, it seems any citizen could initiate it, seize the suspected killer.
So accusation was a way around the family requirement for the standard homicide case, a kind of emergency valve.
It looks like it functioned that way. Sources, like those around the trial of a guy named Agorastus, suggest that by that time, using accusation even for homicide was seen as legally valid, even if maybe not super common for that specific crime.
So it provided another route.
Yeah, a procedural safety net. If the family failed to act, or couldn't, the community wasn't powerless. Any citizen could, in theory, use accusation to bring a suspected killer to justice quickly. It just shows how layered Athenian law was constantly juggling ancient custom, family roles, and the practical need for public order.
It really seems like the Athenians were always trying to find this balance, right? Balancing the strict rules of law with what felt fair or necessary in a specific situation. Which brings us back to arbitration and that idea of equitable law, epikeia, as Aristotle called it.
Yes, Aristotle really thought about this. He saw that just rigidly sticking to the exact wording of the law doesn't always produce the best kind of justice. Life's too complicated for that.
So he defined decency, being kind and decent, as something that improves on strict legal right.
Exactly. He called it an amelioration of what's strictly right according to the law. Because laws have to be general, right? They cover categories. But real life happens in specifics, in unique circumstances.
Can you give an example? Where would the strict law fail and decency step in?
Okay, imagine a law says you absolutely must repay a debt on a specific day, no excuses, penalty is severe. But what if the debtor suffers a totally unforeseen disaster right before the due date? Say, a flood wipes out his farm, his only source of income.
The strict law would still demand repayment, ruin him.
The strict letter of the law, yes, court might feel bound to enforce the penalty. But Aristotle would say that applying epikeia, equity or decency, means recognizing the law wasn't intended to be cruel in that specific tragic situation.
So what would a decent approach do?
A decent judge, or importantly an arbitrator, could find a tailored solution. Maybe grant an extension, work out a payment plan, something that honors the debt but avoids needless destruction. Aristotle said this kind of equitable solution is better than one particular form of what's right. It allows flexibility, recognizes human reality, and arbitration is basically the embodiment of that principle, finding the fair fit, not just applying the blunt rule. #tag 5e. The technical and binding nature of Roman dispute resolution.
Okay, let's shift gears slightly and look at Rome for comparison. Because while Athens seems focused on this moral assessment, social harmony, flexible equity, Roman law often feels quite different, doesn't it? More formal, maybe.
Oh, the contrast is really helpful, I think. Roman law, especially as it developed, put a huge emphasis on legal precision, formality, procedures run by magistrates like the praetor, and achieving binding certainty. It's less about the mass citizen jury and more about legal experts and established rules.
So how did that play out in arbitration? They had arbitrators too, right? An arbiter.
They did, yes. Parties could agree to submit a dispute to an arbiter through a formal agreement called a compromissum. But look at the power of that Roman arbiter once they made a decision.
What was the rule?
It's quite striking. Once a Roman arbiter issued his award, his judgment, he could not correct a mistake, even if he realized 5 minutes later he'd messed up.
No going back, even for an obvious error. Nope. The award stood. It was final and binding. That tells you something about Roman priorities, doesn't it? Certainty, finality, ending the dispute definitively, those were paramount. Even potentially over getting the absolute correct outcome in a specific case, the system needed closure.
That's a world away from the iniuria case, which felt so open to negotiation and complex balancing. And the scope of Roman arbitration, the compromisum, could that be defined more tightly too?
Absolutely. Precision was key. The compromisum, the agreement to arbitrate, had to state clearly what was being decided. It could be full, covering potentially all disputes between the two parties, or, more commonly perhaps, it could be specific, limited to one single issue.
Like just the property line dispute.
Exactly, just the boundary between Field A and Field B. And if the arbitration agreement was specific just to that one thing, then any other legal claims the parties might have against each other, say, an unpaid debt completely unrelated to the field remained totally separate and could still be pursued in court.
So very compartmentalized. Define the box, stay in the box. Pretty much. It aimed to prevent future arguments about what exactly had been settled by the arbitrator. Very focused on legal clarity.
This sounds incredibly formal, even for agreements made outside the main courts. And didn't Roman law also have this tricky distinction between different types of private agreements? Pacts versus stipulations? How did that affect things?
Yes. That's fundamental Roman legal thinking. Pactum, a pact, was basically an informal agreement. Like, okay, I agree I won't sue you over this. In Roman law, that was treated mostly as a matter of fact. It could potentially be used as a defense in court, but it didn't automatically create a new, legally enforceable obligation.
Okay, so it's an agreement, but maybe not rock solid legally on its own. What was a stipulation then?
A stipulation was different. It was a formal promise made using a very specific question and answer verbal formula, highly ritualized. And because it was formal, it was treated as a question of law. It immediately created a legally binding obligation that you could directly sue on.
Right, so the form really mattered. How do they handle conflicts? Say you made an informal pact not to sue, but later you made some other agreement that implied you would sue.
The Romans had a pragmatic way through that. If you had an earlier informal pact not to sue, but then later the parties made a subsequent agreement that clearly showed they now did intend to potentially sue or take action, that later agreement essentially canceled out the earlier informal pact.
The later intention overrides the earlier one.
Basically, yes. The defense you might have raised based on the old pact could be defeated by pointing to the newer, contrary agreement. It shows Roman law focusing on the current express will of the parties, even within these less formal agreements, always negotiating, always updating the legal reality between them.
And one last Roman point, accountability. In Athens, arbitration felt voluntary, driven by social pressure. What about the Roman arbiter? Were there time limits? Could they be forced to act?
Roman procedure loved its deadlines. The compromisum agreement would usually set a time limit for the arbitrator to make the decision. If that deadline passed and the arbitrator hadn't ruled, generally, tough luck.
Yeah.
The arbitration was over, finished. The arbiter usually could not be compelled to take it up again. Finality again.
Usually. So there was an exception.
There was. The only main exception was if the arbitrator himself was personally at fault for blowing the deadline. Like if he was just lazy or negligent, didn't show up, deliberately dragged his feet.
If it was his fault.
Yes. In that specific case, the praetor, the magistrate, could potentially step in and compel the arbiter to actually do the job he'd agreed to do, even after the deadline. It's a neat summary of the difference, isn't it? Athens aiming for social peace through flexible equity, Rome seeking legal certainty through defined procedures and personal accountability. Hashtag tag outro. So we've really covered some ground today. We started in the thick of it, the noisy, dramatic Athenian public court, the dikasterion, this place where justice often felt like a moral performance, a battle of reputations, sometimes just another round in an ongoing feud.
Yeah, and then we moved to the quieter spaces, to private arbitration, where people like Phrynion and Stephanus consciously chose not to go the public route. They opted for a custom solution, mediated by people they trusted, aiming for a resolution that felt fair, balanced, even if complicated, like in the iniuria case.
That practice, it was this really pragmatic recognition that sometimes getting along, restoring harmony, required more flexibility than the strict law allowed. A move towards, fairness, equity, fixing the relationship, not just winning the legal point.
It shows this fascinating dual track in Athenian justice. You could go for the big public fight, aiming to crush your opponent, Or you could choose arbitration, aiming for a workable peace, a way to mend community ties.
Exactly.
So thinking about this for you, our listeners,
Hmm.
how does this ancient focus compare to how we often think about justice today? I keep coming back to that final clause in the iniuria arbitration.
The bear no grudges clause.
Yeah, Phrynion and Stephanus were explicitly told they had to be on good terms afterwards. No resentment.
Mm-hmm. You don't often see a modern court order telling litigants they have to stop disliking each other, do you? Mediation might aim for it, but it's not usually a formal, binding part of the judgment.
Right. So that Athenian requirement that the legal process must result in the end of the bad blood, it raises a really interesting question, doesn't it? Did the ancient Greeks see the ultimate goal of justice, not just as punishing wrongdoers or providing a legal fix, but as something deeper, as the actual restoration of peace within the community? Was a legal victory kind of hollow if the social fabric remained torn? What do you think?